Welcome back to the deep dive. Today, we're really plunging headfirst into a stack of material, looking at two deeply dramatic Australian criminal cases.
Hmm.
And these aren't just stories about alleged crimes, they're really about courtroom conflicts that, well, ripped apart families, and in doing so, fundamentally reshaped crucial principles of justice right here in this country.
That's exactly right. We're not just, recounting the basic facts of what happened on a particular day.
Yeah.
We're peeling back the layers on the high-stakes trials, the intense legal battles that followed during the appeals process. These cases really throw a spotlight on the immense pressure faced by lawyers, by judges,
Yeah.
and crucially, the vital checks and balances the system has or is supposed to have to ensure fairness, even when the alleged acts themselves are truly horrific.
Think of this as your shortcut, maybe, to understanding some pivotal moments in Australian legal history. We're going to try and uncover the surprising facts that emerged, the, well, agonizingly difficult decisions made by legal teams.
Hmm. High stakes.
Exactly, and how these courtroom dramas ultimately change the rules of the game, particularly for prosecutors and courts across the nation. Our mission really is to guide you through what happened, introduce you to the key players, show you how the legal strategies unfolded under pressure, and most importantly, reveal the lasting legacy of these events on Australian justice.
Yeah, and we have sources detailing the initial facts, the heated trial arguments, the critical appeal judgments that followed, and the lasting aftermath for those involved, and importantly, for the law itself. It's a lot to get through, but absolutely essential for understanding the system. Okay, let's unpack this.
All right, let's kick off with the first case. It's a story that unfolds in, well, what seems like a quiet rural landscape, the Bathurst and Orange area in New South Wales.
Hmm.
The date is February 24th, 1995. The scene is a house that, like many, seemed ordinary from the outside, but concealed a dark and frankly terrible secret within its walls. This is the core of the Kneebone case, revolving around devastating charges of aggravated sexual assault against a child, the 14-year-old stepdaughter.
Right. And the central figures in this tragedy are Melissa, who is the 14-year-old stepdaughter and the alleged victim. Then there's Michael Kneebone, the stepfather, who is the accused.
Okay.
And Dorothy. Dorothy is Melissa's mother and Michael's de facto partner. And Dorothy's role in this story, as we'll see, is not just central, it's profoundly complicated and ultimately legally critical.
Describe the incident as Melissa bravely recounted it years later. It's just a moment of sickening betrayal, isn't it? Michael assaults Melissa in her own bedroom. She's screaming, terrified.
Yeah.
And then this pivotal, almost unbelievable moment occurs. Dorothy, her mother, enters the doorway of the room. According to Melissa's testimony later, Dorothy witnesses part of the ongoing assault.
It's part of it.
Melissa testified that her mother actually said, "That's enough," to Michael. And for a brief, fragile moment, time seems to stand still, Michael releases his grip on Melissa. But then, in an act that would haunt Melissa and become absolutely central to the legal case, Dorothy turns and walks out of the room,
Leaves her there.
leaving her 14-year-old daughter alone again with her attacker.
It's just a chilling detail from Melissa's account, isn't it? Painting a picture of a mother's inaction at a moment of just desperate need.
Yeah.
And left stunned and unprotected by her mother's departure, Michael's violence reignites. He grabs Melissa again, drags her from the bedroom into the bathroom, and continues this brutal beating.
God.
Her cries would have echoed through the house. But somehow, amidst the terror, Melissa manages to break away. Dazed, desperate, she quickly packs a small bag of just necessities, really, a symbol of her immediate need to escape, and flees the house.
Running from the home, she eventually finds a public payphone. You have to remember, this is 1995, way before mobile phones were common.
Right, different era.
And she calls the people she trusts most, family friends David and Laura Saylord, who lived in a nearby village. They tell her, "Come straight here." Melissa arrives distressed, visibly injured, and collapses into Laura's arms. David, who thankfully was a trained nurse, immediately recognizes the severity of her condition.
Lucky he was there.
Absolutely. He observes extensive injuries, dark bruises already forming on her face, a swollen nose from the beating, and these angry red choke marks clearly visible around her neck. Understanding the gravity and maybe the importance of evidence, the Saylards immediately document Melissa's injuries by taking photographs.
Smart move.
And they strongly, unequivocally urge her, "You have to report this to the police."
So, driven by the Saylards, Melissa goes to the local police station that same evening. She speaks to a Sergeant Anderson, and through, broken sobs and obvious trauma, she manages to report the beating, the physical assault she endured.
Okay.
But the sexual assault, that night, she just cannot bring herself to utter those words. It's too raw, too shameful, too deeply traumatizing in that immediate aftermath. She holds that part of the story inside.
And based on the report of the assault and the documented injuries from the photos, the police act quickly. They get an arrest warrant for Michael Kneebone, but when officers go to the family home to execute the warrant,
They're gone.
it's deserted. Michael, likely sensing the police would be coming, has convinced Dorothy, Melissa's mother, to flee New South Wales with him. Within days of the incident, they're gone, heading north towards Queensland. It's possible he coerced her, or maybe her loyalty or denial was so deep she went willingly. Either way, they vanished.
Yeah, and despite their flight, the legal process for that initial assault charge against Michael actually proceeds in the Bathurst District Court.
Yeah.
Because he was deemed to be intentionally evading court, a deliberate act to avoid justice. Michael is tried and, somewhat unusually for a serious charge like assault, convicted in his absence.
Wow. Okay.
Yeah, that conviction stands. Meanwhile, for her own safety and well-being, Melissa is placed into foster care.
Life in foster care is, as you can imagine, incredibly difficult for Melissa. But over time, away from that toxic environment of her home, she gradually finds some stability and begins to heal. And it's in this new, safer environment, more than a year later, in mid-1996, that the full, terrible truth finally begins to emerge. Confiding in her foster mother's teenage daughter, a peer, someone she could trust, Melissa finally reveals the rape.
The full story.
And critically, the horrifying fact that her own mother, Dorothy, had witnessed part of it and done absolutely nothing to help her.
This revelation is, well, it's a seismic shift. It triggers a new, far more intensive police investigation, this time led by detectives focused squarely on the sexual assault allegations. As part of this, detectives re-interview Dorothy, who is eventually located.
Right.
But incredibly, despite her daughter's now detailed account, which is supported by objective evidence of injury from the Sailor's photos,
The photos, yeah.
Dorothy still denies any assault took place. She sticks rigidly to her original brief statement to police from February 27, 1995, just after they fled, where she simply claimed nothing happened.
Investigators are highly suspicious. They believe Dorothy is lying to protect Michael, whether it's out of deep-seated loyalty, maybe fear of him, or perhaps a complicated mix of both. But now, they have Melissa's clear, detailed, and consistent account of the sexual assault, powerfully corroborated by the Sailor's photos showing the brutal physical violence she suffered that night.
So armed with this comprehensive evidence, prosecutors from the NSW Director of Public Prosecutions, the DPP, they decide to pursue the more serious, aggravated sexual assault charges against Michael Kneebone. Tracking Michael down after 3 years on the run takes time, but he is eventually located, arrested, and extradited back to New South Wales in early 1998.
Right.
After years of waiting, the stage is finally set for a major trial.
So the trial begins in the Orange District Court in July 1998. Presiding is a Judge John Cooper, a steady hand, overseeing a courtroom just filled with palpable tension. Melissa, now 17, a young woman who has endured years of trauma and legal uncertainty, is there.
Must have been incredibly difficult.
Facing Michael Kneebone across the courtroom for the first time in years. Sources note he barely meets her days. It isn't a massive media circus trial. There are just a few local reporters present. The community's sort of aware of the quiet, grim case unfolding.
Yeah, and the legal teams are critical to understanding the events that follow. For the Crown, the prosecution's case is presented by a seasoned Crown prosecutor from the NSW DPP's office. The sources don't name him, but describe him as experienced.
Okay.
Michael Kneebone's defense is handled by a local barrister, not a Queen's counsel, instructed by Maureen Fanning and Associates, who have been Michael's solicitors throughout this whole long process. Maureen Fanning herself remained a steadfast presence supporting Michael.
So the challenge for the Crown prosecutor is significant. This is a historical sexual assault case with no supporting forensic evidence of the rape itself, largely because so much time had passed before Melissa felt able to disclose it fully.
Right, the delay is key.
The prosecution's case hinges almost entirely on Melissa's courage and her powerful, credible testimony. And then there's that huge silent presence in the background. Dorothy, the mother, the potential eyewitness who has repeatedly denied anything happened.
And the prosecutor makes a move in his opening address that immediately draws attention. He lists Dorothy as a potential witness for the Crown.
Okay.
He tells the jury that he might call her, hinting that it's part of a prosecutor's fundamental duty to present all material evidence to the court, even if that evidence might not necessarily strengthen the prosecution's case or could even be unfavorable. This directly invokes that crucial legal principle that a prosecutor acts as a minister of justice, not just as an advocate trying to win.
Michael Kneebone's defense team, led by their barrister and instructed by Maureen Fanning, is visibly stunned by this. Dorothy has consistently denied the assault. Surely her testimony would undermine the Crown's case, not support it. Why would the prosecution even consider calling her?
Yeah, it doesn't make sense on the surface.
They scramble to adjust their strategy, bracing themselves for the possibility of cross-examining her if she does take the stand for the Crown.
Okay, so over the first day of the trial, the jury hears Melissa's testimony. It is clear, detailed, delivered with raw emotion. She recounts the verbal abuse, the terrifying physical beating, the sexual assault, and that haunting, indelible image of her mother standing in the doorway, watching, and then leaving.
Just devastating.
And she explains, with painful honesty, the reasons for her delay in reporting the sexual assault. She was scared, deeply ashamed, and she adds the crushing detail, "My mom didn't believe me," when she tried to tell her mother shortly after the incident.
On cross-examination, Michael's defense barrister employs a tactic that, while legally necessary for their case, is undoubtedly difficult and painful to watch. They attempt to chip away at Melissa's credibility, suggesting that perhaps she fabricated the rape allegation later, fueled by anger or a desire for revenge against her mother and stepfather.
A tough line, but standard defense tactic in these situations.
It's a tough line of questioning, attempting to create doubt about her account years after the event. Michael himself, having pleaded not guilty to the rape, admits only to having smacked her around that day, a stark minimization of the violence Melissa described.
Yeah, hardly capturing the severity. But then comes this sudden dramatic turn in the trial. On the second day, the Crown prosecutor informs the defense team that he has changed his mind. He will not be calling Dorothy to give evidence after all.
Whoa! Okay, why? Michael's barrister immediately presses the prosecutor for an explanation. What does he say?
The prosecutor states his reason. He has formed the opinion that Dorothy's evidence would be unreliable. He explains his belief that she is firmly, in the defense camp, loyal to Michael, and that her initial denial to police was a lie intended to protect him. He essentially concludes that calling her wouldn't assist the court, and could even potentially mislead the jury if she repeated her denial under oath.
This decision throws the trial into a significant legal dilemma, doesn't it? One that goes right to the heart of that Minister of Justice principle we mentioned. The High Court case of R.V. Apostoles from 1984 set out clear guidelines or propositions, as the court called them, on a prosecutor's duty regarding witnesses. While it says the prosecution must call all material witnesses, it also acknowledges they can exercise discretion if there are good reasons, like a witness being genuinely unreliable. Dorothy was undoubtedly a material witness, an eyewitness to crucial events. So the legal question becomes, was the prosecutor's reason for not calling her valid under Apostoles? Or was he improperly withholding evidence, perhaps to avoid putting a potentially unfavorable witness before the jury?
And Michael's defense team is understandably furious. Their trial strategy partly relied on the opportunity to cross-examine Dorothy if the Crown called her, using her consistent denial of the assault to support their argument that Melissa's account was false. Now, that opportunity is gone.
So they face a new, tricky dilemma. Should they call Dorothy themselves as a defense witness?
It's incredibly risky. They haven't had the chance to properly interview her themselves, specifically about the sexual assault allegations. The only statement they had access to was her brief denial to police about the assault. They have no idea how she would hold up under cross-examination, this time from the Crown, who now clearly views her as hostile.
Right.
After what sources describe as frantic discussion between Michael's barrister and solicitor Maureen Fanning, his legal team makes a difficult decision. They decide not to call Dorothy either.
Okay. What was their reasoning?
Their reasoning seems to be that if the Crown, with all its resources, deemed her unreliable and wouldn't call her, perhaps her absence is the stronger argument for the defense. They decide it's better to rely on the Crown's burden of proof and argue that the prosecution has failed to bring a crucial witness, thereby creating reasonable doubt, rather than risking calling her and potentially having her testimony damage their case.
So the trial concludes without the jury hearing from Dorothy. Her absence becomes the silent, powerful factor just hanging over the proceedings. In his closing argument, Michael's barrister seizes on this. He argues forcefully that Dorothy's absence creates reasonable doubt. He puts it to the jury. If her testimony would have supported Melissa's account or the prosecution's case, why wouldn't the Crown have called her? The clear implication is that her testimony wouldn't have supported the Crown.
After 2 intense weeks of evidence and argument, the jury retires to deliberate. They send out one note to Judge Cooper, highlighting the very issue the defense had raised. Why didn't we hear from the mother?
Ah, the key question.
Exactly. Judge Cooper responds carefully, adhering to the law. He instructs the jury not to speculate on what an absent witness might have said. He reminds them firmly that the prosecution bears the burden of proving the case beyond reasonable doubt, and that the defense has absolutely no obligation to call any witness, including the mother. It's a correct statement of law, but you can imagine the jurors still grappling with that unanswered question in their minds.
Finally, the verdict is delivered. Guilty. Michael Kneebone is convicted of aggravated sexual assault of a child. For Melissa, it's a moment of immense, hard-fought relief and validation, a form of justice after years of silence and pain. But it's undoubtedly bittersweet knowing that her own mother's loyalty remained with Michael, even to the point of denying the truth.
Yeah. And at the sentencing hearing a few weeks later, Dorothy does appear, this time called by the defense, likely in a last-ditch effort to garner some leniency for Michael.
Interesting.
She takes the stand and repeats her consistent, steadfast denial. Nothing like that happened, and she never saw Michael do any such thing. Notably, the prosecutor makes the decision not to cross-examine her at this stage. Judge Cooper, in delivering his sentence, specifically notes Dorothy's denial, but pointedly reminds her that her daughter's powerful testimony contradicted her, implicitly accusing Dorothy of lying by omission in court. Judge Cooper sentences Michael Kneebone to a substantial term of imprisonment. While the exact term isn't recorded in the sources for that year, for such an offense in 1998, it would typically have been many years.
Most people, hearing that, would assume the story ends there. Michael Kneebone is convicted, serving time, but for Michael, and more importantly for Australian law, the legal battle was far from over.
Right.
From behind bars, he maintains his trial was unfair, arguing that the Crown's decision not to call Dorothy deprived him of a fair hearing. His appellate lawyers seize on that critical issue, the missing eyewitness. In late 1998, they file a notice of appeal to the NSW Court of Criminal Appeal alleging a substantial miscarriage of justice occurred.
And this is where R.V. Kneebone moves from being, a local tragedy to a landmark case on prosecutorial ethics and that Minister of Justice principle. The appeal hearing takes place on August 6, 1999, in the formal setting of the Banco Court in Sydney. 3 senior judges sit on the bench to hear the arguments. Chief Justice James Spiegelman, Justice Greg James, and Acting Justice Rodney Smart.
And Michael's legal team changes significantly for the appeal, bringing in specialized appellate counsel. Representing the appellant, Michael Kneebone, is Stephen Norrish QC, a highly respected senior public defender known for his expertise in criminal appeals.
Top barrister.
He has come on board specifically to argue the complex legal points. He is instructed, however, by Michael's persistent solicitor, Maureen Fanning, who has remained committed to his case from the very beginning, through trial and now appeal.
Facing them for the Crown, representing the state of New South Wales, is T. Budden SC, another seasoned advocate and senior counsel from the DPP, who would also later become a judge. He is assisted by D. Howard, one of the prosecutors involved in the original trial, and instructed by C.K. Smith, a senior solicitor from the DPP's office. It's a real heavyweight legal battle with senior counsel on both sides dissecting the fundamental principles of trial fairness.
Stephen Norrish QC argues forcefully for Michael. His central argument is that the Crown's failure to call Dorothy was a fatal error that rendered the trial unfair. He emphasizes she was an eyewitness to crucial moments surrounding the alleged crime, a key part of the narrative arc Melissa presented. By not calling her, the Crown deprived the jury of hearing potentially material evidence her version of events, however unreliable the Crown thought it might be, and critically, prevented the defense from cross-examining her on her consistent denial of the assault, which could have cast doubt on the sexual assault allegations.
And Norrish QC argues that the prosecutor's stated reason for not calling her, that her evidence would be unreliable because she seemed aligned with the defense, wasn't a sufficient justification under the apostolities principles, especially given her centrality. And here's a critical point that emerged during the appeal. The DPP conceded that Dorothy had never been properly interviewed by police or the prosecution specifically about the sexual assault allegations themselves, only about her initial denial of the assault.
That seems crucial.
Very. T. Budden SC for the Crown defends the original prosecutor's decision. He argues that Dorothy's testimony was indeed inherently unreliable because she had demonstrably lied to police initially and was clearly aligned with Michael. He leans heavily on the apostolities case, arguing the trial prosecutor had a valid discretion to decide not to call a witness they genuinely believed to be unreliable and potentially misleading to the court. He also points out, quite fairly, that the defense themselves could have subpoenaed Dorothy to give evidence. She was, in fact, waiting outside the courtroom during the trial, available to be called by either side. He argues the defense made a tactical decision not to call her and couldn't now complain about her absence.
Right, a tactical gamble they lost, perhaps?
That was the Crown's argument. After the arguments conclude, the court reserves its judgment to consider the complex legal principles. Several weeks later, on September 21, 1999, the Court of Criminal Appeal delivers its judgment. Justice Greg James, with Chief Justice Spiegelman concurring, writes the lead opinion, and it is highly critical of the Crown's conduct.
Really?
Yes. Justice James emphasizes the prosecutor's paramount role as a minister of justice. Their duty is to assist the court in achieving a fair trial, not simply to win a conviction. He concludes that the Crown fell short of that standard in Michael Kneebone's trial.
Wow. So what was the specific finding?
Justice James finds that Dorothy was indeed an eyewitness to critically important circumstances surrounding the alleged crime. He states that the jury deserved to hear her account, whatever its limitations, even if it contradicted Melissa's testimony. He ruled that the prosecutor's failure to properly investigate what Dorothy would say about the sexual assault allegations, specifically the DPP's concession on appeal that this wasn't done, was described as most unsatisfactory by the court.
Most unsatisfactory. Strong words.
Very. It meant that the decision not to call her was not based on a sufficiently sound foundation of genuine unreliability concerning the central allegations.
So the decision is a major one. Michael Kneebone's conviction for aggravated sexual assault is quashed, and a new trial is ordered.
Correct. Which means Michael is likely released on bail, at least temporarily, facing the prospect of being tried again. For Melissa, the victim, this is just devastating news. After finally achieving a measure of closure with the conviction, she is now faced with the agonizing prospect of having to relive the entire trauma, testifying against Michael again in a new trial.
And the source material doesn't actually record the final outcome of the case after the conviction was quashed, does it?
No, it doesn't. It's unknown whether Michael Kneebone was actually retried or if the Crown decided not to proceed again. Perhaps due to the legal difficulties highlighted by the appeal judgment, the passage of time, or potentially taking into account Melissa's wishes regarding facing a second trial. We just don't know the final chapter there.
But the legal legacy of R.V. Kneebone is crystal clear and continues to resonate today. It became a significant precedent, particularly in New South Wales, on the scope and limits of a prosecutor's discretion in calling witnesses under apostolites.
Absolutely. Prosecutors across Australia took heed from this powerful judgment from the state's highest appeal court. The message was unequivocal. If you have a witness as central to the narrative as an alleged eyewitness to crucial circumstances, especially someone like the victim's mother, you must have a solid, justifiable, investigated reason not to call them.
You can't just assume.
Exactly. You can't just assume they'll be unreliable or align with the defense. And you must be transparent with the court and the defense about your decision and your reasons.
This case directly led to specific updates in the NSW DPP prosecution guidelines. Now, one guideline explicitly mandates the prosecution must confer with the witness before making a decision not to call the witness. And it cites R.V. Kneebone as the foundational authority for that rule. It's now taught in Australian law schools as a classic illustration of the Minister of Justice principle in action, reinforcing that the prosecutor's fundamental duty is fairness, not merely securing a conviction. It underscores that withholding a material witness, particularly an eyewitness, without a sound investigated reason can amount to a miscarriage of justice.
It also connects to broader principles about missing evidence, maybe echoing cases like Dyer's. Yeah, somewhat. While Dyer's is more about the jury's approach to missing evidence that the defense might have provided, Kneebone confirms that if critical evidence, like a witness's account, is missing because the Crown didn't present it without proper justification, the jury can consider whether that failure raises a reasonable doubt about the prosecution's case. It prevents speculation and keeps the focus on the evidence actually presented or properly explained as absent.
So that's the story of Michael Kneebone, Melissa, Dorothy, and the missing witness. A case born from devastating family violence transformed into a legal battleground that ultimately redefined how prosecutors exercise their ethical duties in the courtroom. It's a powerful demonstration of the critical function of the appeal process in catching errors that happen in the heat of a trial.
Absolutely. And the second case we're diving into today, the Mahmood case, pivots our focus to another crucial aspect of trial fairness and the role of appellate courts. How partial evidence is handled, specifically the potential misuse of selective video snippets and how they can be used to influence a jury and what judges must do about it.
Okay, this story takes us across the continent to Perth, Western Australia. The date is July 4th, 2004. It's a quiet Sunday night at the kebab-shop restaurant in the suburb of Metlawley.
The key players here are Dilshad Mahmood, a 37-year-old Iraqi immigrant and the owner of the restaurant who is the accused husband, and Shnar Debag, his 40-year-old wife and co-owner of the business, who is the tragic victim.
And the backdrop to the events of that night is a deeply troubled marriage. The sources indicate Mahmood had suspected Shnar of infidelity for some time and, troublingly, had even hired private investigators to follow her before her death.
Yeah, that detail paints a picture of intense jealousy and a possible motive rooted in suspicion and perhaps cultural concepts of honor or shame.
On the night of the murder, according to Mahmood's account given to police, Shnar went to the toilet located in the back passage of the restaurant while he was cleaning up at the end of the night. When she didn't return, he went to check on her and discovered a horrific scene. She was in a pool of blood, her throat deeply cut.
Terrible discovery. And the murder weapon, a knife, was nowhere to be found despite subsequent searches.
Mahmood's account of his immediate reaction is one of frantic, hysterical shock. He describes finding his wife, lifting her body instinctively, an action that would later be scrutinized for how it might explain bloodstones.
Right, the blood transfer.
Forgetting her blood on his clothes, searching frantically outside the restaurant for an attacker, finding no one, and then desperately calling emergency services and his son for help. He claimed he was utterly distraught.
So police arrive quickly at the kebab-shop restaurant to a chaotic scene. Mahmood is present, visibly upset, near hysterical, his clothing smeared with his wife's blood. But amidst the tragedy, detectives are trained to observe. They notice points that raise suspicion. There's no sign of forced entry into the restaurant. There's no indication of robbery. Kunar's handbag is still there with cash inside.
Okay.
And while Mahmood's distress is evident, his behavior, viewed through a forensic lens, raises questions. One specific, peculiar detail catches their eye. There's blood inside Mahmood's right trouser pocket.
Inside the pocket? That is odd.
An odd place for blood to transfer if his account of simply finding and lifting his wife's body is the sole explanation.
Later that same day, police conduct a formal videotaped interview with Mahmood. He waives his rights, agrees to speak freely, recounting his story of finding his wife, searching outside. He vehemently denies having killed her or knowing who did. He does mention his prior suspicion of an affair with Shnar and visibly gets choked up when discussing this, adding another layer to the potential motive. Police also note a scratch on his forearm, which he attributes to cutting himself on a broken plate during his frantic reaction to finding Shnar's body.
Okay, so explanations offered. But the police naturally remain suspicious. Statistically, the husband is often the primary suspect in such cases.
Forensic results begin to solidify the picture in late 2004. The autopsy confirms Shnar's death was caused by a single, deep knife wound to the neck, indicating a deliberate act of fatal violence. Despite extensive searching, the murder weapon is never recovered.
Still missing.
But the analysis of the bloodstain in Mahmood's right trouser pocket confirms it is Shnar's blood. The prosecution starts to form a theory. Perhaps Mahmood, after the stabbing, hastily stuffed the bloody knife into his pocket before disposing of it somewhere, explaining the unusual blood location. Mahmood denies this outright, offering no alternative explanation for the blood inside his pocket beyond his general frantic actions.
And the motive crystallizes around the intense jealousy fueled by those private investigator reports and past confrontations about the alleged infidelities. In February 2005, Mahmood is charged with willful murder. He pleads not guilty, steadfastly maintaining that an unknown assailant came into the restaurant and killed his wife.
So the case proceeds to trial in the Western Australian Supreme Court the following year. And it is, at its heart, a purely circumstantial case, isn't it?
Absolutely. No eyewitness to the killing, and crucially, no murder weapon ever found. The prosecution's case is built like a mosaic, piecing together the available evidence. The motive of intense jealousy and suspected infidelity, Mahmood's opportunity to commit the crime as he was present, and that puzzling bloodstain inside his pocket.
And the defense strategy.
To argue for reasonable doubt, suggesting that someone else, perhaps Snar's alleged lover or someone connected to him, could have been the killer.
The trial judge is Justice Lindy Jenkins, a respected figure in the WA legal community who had previously served as a senior prosecutor for the WA DPP, so she brings significant courtroom experience to the bench. The trial unfolds, and a particular piece of evidence, a video recorded by police, becomes a real flashpoint of legal controversy.
Right, tell us about this video. About a week after the murder, as part of the police investigation, Mahmood accompanied officers back to the kebab-shop restaurant to perform a walkthrough. This was recorded on video, spanning over 2 hours, during which Mahmood reenacted his account of finding his wife and explained his actions.
Okay, a standard police procedure sometimes. So during the trial, Mahmood's defense counsel decides to make use of this video. During cross-examination of a police officer, they ask about the walkthrough, specifically how Mahmood demonstrated lifting his wife's body,
Right.
hoping to use this to explain how blood might have gotten onto his clothes in a way consistent with his story. The officer being questioned wasn't present for the filming and couldn't recall the specific detail of the demonstration.
So the defense then takes a critical step. They seek to tender part of the walkthrough video as evidence.
Huh.
They offer a specific 6-minute segment that shows Mahmood's actions in holding the body, intending to use it to demonstrate a plausible mechanism for the blood transfer onto his clothes. They actually offered to tender the whole video.
The whole 2 hours?
Yeah, perhaps believing it would show other aspects of his demeanor, like distress maybe. But the prosecution objects vehemently to the admission of the entire video, calling it self-serving and raising other unspecified issues with it.
And the trial judge, Justice Jenkins, she sides with the prosecution on this point and rules that only the 6-minute segment specifically depicting the body lifting action will be admitted into evidence.
Hey, what?
However, recognizing the potential unfairness of showing only a small snippet of a much longer video, especially when it comes to assessing a person's emotional state, Justice Jenkins attempts a compromise direction to the jury. She indicates to the lawyers that she intends to instruct the jury not to read too much into Mahmood's apparent calmness or lack of overt emotion in that isolated 6-minute clip.
Right, try before.
She plans to tell them they would be unwise to draw any adverse view of Mr. Mahmood's demeanor from that segment alone, precisely because it's a small part of a longer interaction film a week after the traumatic event.
During closing arguments, the prosecutor, despite the judge's stated intention for a cautious direction, seizes on that limited 6-minute video snippet. He argues directly to the jury that Mahmood's reaction when reenacting finding his wife in that clip was cold-blooded and clinical.
Oof, that's strong language.
Very. He suggests this detached demeanor was evidence of his guilt, not the behavior you'd expect from an innocent grieving husband. The defense barrister is immediately outraged, objects strongly, and argues that the prosecutor is misrepresenting the evidence and taking the snippet completely out of context. Justice Jenkins allows the prosecutor's argument to stand, reminding the defense that they can address it in their own closing.
So after hearing all the evidence and arguments, the jury deliberates and ultimately finds Dilshad Mahmood guilty of willful murder. Local news headlines report the conviction, often labeling him the kebab-shop killer, reflecting the grim details of the case and the location. The trial judge, Justice Jenkins, subsequently sentences Mahmood to a substantial term of imprisonment. The source notes placing it at a minimum of 18 years before parole eligibility.
From prison, Mahmood launches an appeal against his conviction to the Western Australian Court of Appeal in 2007. Among his grounds of appeal are the trial judge's handling of the walkthrough video evidence, specifically the decision to only admit the 6-minute snippet, the prosecutor's comments on his demeanor drawn from that snippet in closing argument, and the judge's subsequent direction to the jury regarding that snippet.
Okay.
He also appeals the inference the prosecution invited the jury to draw from the blood in his pocket.
Right. At the WA Court of Appeal, a critical moment occurs. The prosecution, perhaps realizing the precariousness of the trial prosecutor's conduct, actually concedes that the argument about Mahmood's demeanor made using only the 6-minute video snippet was misleading.
They conceded that. Wow.
Yes. They acknowledge that Mahmood did display signs of distress in other parts of the full 2-hour walkthrough video that the jury never saw. However, they argue that Justice Jenkins' direction to the jury at the end of the trial was sufficient to cure this unfairness and prevent any miscarriage of justice.
Okay, so they admit the problem but say the judge fixed it. The WA Court of Appeal judges Robert Smith, J.A., Bus, J.A., and McClure, J.A. ultimately uphold Mahmood's conviction. The majority, Robert Smith and Bus, J.J.A., find no error in Justice Jenkins' initial decision to refuse tendering the full video and conclude that her direction to the jury regarding the snippet was sufficient to warn them against drawing adverse inferences about Mahmood's demeanor.
And McClure, J.A.
McClure, J.A. while acknowledging that the prosecutor's inference from the snippet was a material argument that shouldn't have been made based on incomplete evidence, also agrees that the trial judge's direction was sufficient in the circumstances and that no substantial miscarriage of justice occurred. So, appeal dismissed at that stage.
But Mahmood and his legal team don't give up. They seek and obtain special leave to appeal to the highest court in Australia, the High Court, located in Canberra. This final crucial hearing takes place on January 30th, 2008.
Yeah, picture the scene. The grand, imposing High Court building in Canberra. 5 of the nation's most senior judges are on the bench, ready to hear arguments that could decide a man's fate and clarify fundamental legal principles. Presiding is Chief Justice Murray Gleeson, alongside Justices Michael Kirby, William Dummo, Kenneth Hayne, and Justice Susan Kiefel, who was at that time the court's newest member, having been appointed just 2 years prior.
And the legal teams arguing before the High Court are formidable, highly respected. Representing the appellant, Dilshad Mahmood, is Dr. J.J. Edelman, a barrister already gaining a reputation as a brilliant advocate despite his relative youth.
And a future High Court justice himself, as it turned out.
Exactly. He is assisted by C.H. Withers as junior counsel and instructed by Cott Gunning Lawyers, the firm that had represented Mahmood throughout the lengthy process since the trial.
And arguing for the respondent, the state of Western Australia, is Bruno Fianica, SC, a highly experienced senior counsel from the WA-DPP, who would also later be appointed to the bench as a judge. He is assisted by D.A. Lima. It is a legal battle fought by some of the sharpest legal minds in the country.
The core issues argued before the High Court center on whether Mahmood's trial was rendered unfair by how that 6-minute video snippet was handled specifically, the trial judge's ruling to admit only part of the video, the prosecutor's explicit argument in closing based on Mahmood's demeanor in that snippet, and the trial judge's direction to the jury regarding that argument.
And the secondary issue was whether the jury could properly draw an inference of guilt from the presence of blood inside Mahmood's pocket.
The High Court delivers its decision remarkably quickly on the very same day as the hearing, January 30th, 2008.
Very quick.
The decision is unanimous. In a single, powerful joint judgment delivered by all 5 justices, they make a split ruling. They allow the appeal on the video demeanor ground, but dismiss the appeal on the bloodstain ground. Crucially, they set aside the order of the WA Court of Appeal and remit the case back to the WA Court of Appeal for further hearing and disposition.
Okay, so unpack that. The High Court's reasoning on the video and demeanor issue is absolutely crucial and becomes a key precedent. They rule that Justice Jenkins's direction to the jury that they would be unwise to draw an adverse inference from the snippet was inadequate in the circumstances. It was phrased as an opinion, not a clear mandatory warning.
Not strong enough.
Exactly. Given the prosecutor's explicit and potentially highly prejudicial argument in closing, labeling Mahmood as cold-blooded and clinical based solely on that short clip, the High Court found that the judge was required to direct the jury unequivocally to disregard that inference entirely, because the jury lacked the full context of the 2-hour video to properly assess his demeanor. The failure to provide a strong direction that effectively denied the evidentiary effect of that snippet for the purpose of assessing Mahmood's demeanor related to guilt was deemed an error of law. This ground of appeal succeeds.
So it sends a clear, sharp warning to prosecutors across the country.
Definitely. If you successfully object to the tender of the full context of evidence, like a police interview or walkthrough, you cannot then exploit a partial snippet of that evidence, particularly concerning a defendant's behavior or emotional state, to invite adverse inferences from the jury in your closing argument, unless the judge provides an extremely strong, explicit, mandatory direction telling the jury to ignore any such inference drawn from that incomplete context.
Right. And on the bloodstain issue, the High Court disagreed with Mahmood's argument there. While the prosecutor had suggested the blood got there from a knife being placed in the pocket, the High Court notes that this specific inference about the knife wasn't proven. But crucially, the trial judge did appropriately direct the jury not to draw that specific inference about a knife from the blood evidence because it wasn't supported by proof. Mahmood had the opportunity during his own evidence to explain the presence of the blood in his pocket, but offered no innocent explanation beyond simple denial. The High Court found that the judge's direction on this specific point about the blood was sufficient to prevent a miscarriage of justice on that ground.
So while the blood stain argument failed, the High Court found the video demeanor issue so significant that it rendered the trial unfair. The conviction is effectively quashed by the High Court's finding of legal error. The order to remit the case back to the WA Court of Appeal means that appeal court must now reconsider the case in light of the High Court's ruling.
And they have to decide what exactly.
They have to decide if, despite the error concerning the video snippet, there was still no substantial miscarriage of justice, under the state's Criminal Appeal Act essentially, was the other evidence of guilt, motive, opportunity, the unexplained bloodstain, so overwhelming that this error couldn't have affected the verdict? Or is a retrial necessary? And again, the source material doesn't record the final outcome from the WA Court of Appeals reconsideration after the High Court's ruling.
So, in practical terms, the High Court's decision meant Mahmood's conviction was set aside. News headlines the next day reflected this. High Court allows WA murder appeal conviction quashed. This placed Mahmood in a state of legal limbo, his guilt not finally determined, awaiting the WA Court of Appeals decision on whether he would face a retrial.
In these two cases, Kneebone and Mahmood, though different in their facts and the specific legal errors they addressed, offer incredibly powerful lessons. They've had a significant lasting impact on Australian legal practice, particularly concerning criminal trials and appeals.
They both fundamentally reinforce and clarify that critical principle of the prosecutor as a minister of justice, don't they?
Absolutely.
It's not just a fancy term. It means their duty is higher than merely winning. It's about ensuring the trial process itself is fair and just for everyone involved, the victim, the accused, and the community.
And Kneebone provided such a stark, real-world example of the limits on a prosecutor's discretion when it comes to calling witnesses. It clarified that you cannot arbitrarily decide not to call a material witness, especially an alleged eyewitness, simply because you think they might not help your case or you perceive them as unreliable, without conducting a proper investigation into what their evidence actually is, particularly regarding the central allegations.
That concession in Kneebone that Dorothy hadn't been properly interviewed about the sexual assault allegations themselves was key, wasn't it?
Absolutely key. The case reinforced the apostolities principles with practical force, leading directly to those updated NSW DPP guidelines requiring prosecutors to confer with witnesses. It's now a foundational case taught to law students and new prosecutors about the ethical dimensions of their role. It hammers home that improperly withholding a material witness is not a legitimate tactical decision, but a potential miscarriage of justice.
And Mahmood, on the other hand, provided vital clarity on the handling of partial evidence, particularly in areas like police interviews or reenactments. It created a strong precedent, sometimes referred to as the Mahmood direction.
That's right.
About the need for very strict judicial directions when selective snippets of a defendant's behavior or demeanor are presented to the jury. The High Court said clearly that if the prosecutor successfully prevents the defense from putting the full context before the jury, they cannot then exploit a snippet in closing to invite negative inferences about the defendant's character or truthfulness. The judge must intervene powerfully and direct the jury to disregard any such inference drawn from that incomplete evidence.
Yeah, this case made judges more vigilant about how prosecutors comment on a defendant's demeanor based on isolated moments captured on video. It empowers trial judges to give those strong corrective directions and signals to appellate courts that they should be willing to overturn convictions where such prosecutorial overreach isn't adequately neutralized by the judge.
And it resonates with that Dyer's principle we touched on earlier.
It does, reinforcing that juries shouldn't speculate or draw unfair inferences from missing evidence. Instead, they should focus on whether the available evidence proves the case beyond reasonable doubt.
Both Kneebone and Mahmood are powerful case studies demonstrating the absolute critical function of the appellate court system in Australia, the state courts of criminal appeal, and ultimately the High Court. Trials are intense, complex proceedings, and errors can and do occur.
They certainly do.
The appeal process acts as a vital safeguard, providing a mechanism for reviewing those errors and ensuring that they don't result in unjust outcomes, thereby maintaining public confidence in the integrity of the justice system, even in the most difficult cases.
And behind all these legal principles and court judgments are the undeniable human costs. In Kneebone, you have Melissa, the victim, who achieved a conviction, but then faced the added trauma of the appeal and the uncertainty of a potential retrial, coupled with the enduring pain of her mother's stance. Michael Kneebone had his conviction quashed by the highest court in the state, gaining a second chance. But the ultimate resolution of his case isn't publicly known from the sources.
And in Mahmood's case, his conviction was quashed by the High Court, sending it back to WA his ultimate fate unknown to us. He may have been wrongfully imprisoned for years if truly innocent, or he may have been guilty but still benefited from the system insisting on a fair process.
And central to his story is the tragic death of Shnar Dabeg, the victim whose life was violently taken, leading to years of legal proceedings dissecting the circumstances of her death.
These stories, though focused on the gravity of alleged crimes and intricate legal principles, ultimately serve to underscore fundamental principles that are designed to protect everyone who might interact with the justice system, whether as a victim, witness, or accused.
Yeah.
The rules of evidence, the procedures followed in court, the ethical duties of lawyers. These aren't just dry technical points, they are the essential framework upon which a fair trial is built.
They remind us that the pursuit of justice requires the highest ethical standards from those who represent the state and constant vigilant oversight from the courts to ensure that the process itself remains just.
These cases really challenge us to think deeply, don't they? How do you, listening, balance the crucial need for accountability for alleged wrongs with the absolute non-negotiable necessity of a fair and just process for the accused, regardless of how difficult the circumstances or how compelling the initial evidence might seem? It's a tension right at the heart of the system, illuminated by these dramatic stories.
And that was our deep dive into two cases that left an undeniable, important mark on Australian criminal law and legal practice.
They serve as powerful reminders that the pursuit of justice is rarely simple. It involves navigating complex ethical standards for those who represent the state and requires constant vigilance and rigorous review from the courts at every level.
Yeah, from a conflicted mother's heartbreaking silence and inaction to the potentially misleading use of a brief video snippet, these stories show just how crucial every detail, every legal decision, and every word spoken in court truly can be in the pursuit of a just outcome. Thank you for joining us for this deep dive.